perhaps don't understand the seriousness of the first court hearing and precisely what it is that they need to do in order to prepare for that hearing to be in a position to proceed on that first occasion.
Okay, so when we talk about court hearings, what are we specifically talking about today? Are we talking about the family side or the criminal side?
No, we're talking about criminal. Of course, court hearings can take place in all kinds of areas of law. In the civil jurisdiction where there's family, there's, for example, commercial courts, county courts and so forth. But what we're talking about is predominantly criminal defence work. And in that respect, all criminal cases always start life in the magistrate's court.
That's right.
Irrespective of the offence that the person has been charged with, whether it's murder, manslaughter, rape, common assault, drink driving, assault occasioning actual bodily harm, burglary, fraud, every single criminal case always commences its life in the magistrate's court at first instance. And in that respect, there's effectively one of two ways in which a person can find themselves before the court in terms of getting to court. One is when a person has been charged by the police and either refused bail or remanded in custody to appear before the court, which is usually the following morning. Or alternatively, a person can be what's called postal requisitioned, what used to be called a summons. Summons to appear before the court, and they have to attend at the magistrate's court at that first hearing. And that's really what we're concerned with precisely today, is what happens at the first hearing in the magistrate's court, what is the purpose of that hearing, what is the person going to be expected to do, what kind of preparation does a person need to undertake prior to that hearing, if any.
Okay, well, so should we get started with the first question then? So what actually happens at the when you enter the magistrate's courts?
Well, initially, whenever anybody is being charged or summoned to appear before the court, typically they're obliged to attend court at 9:30 a.m. that morning. But of course, sometimes they can be charged and bailed or prosecuted to appear before an afternoon court. But typically, they have to attend at 9:30 a.m. in the morning, usually if they're on bail to comply with their bail. And typically, hearings start from 10 a.m. onwards. Now, the way in which it works within the criminal courts is that the people don't have an allocated time slot for their hearing. So everybody who has been charged and bailed to appear before the court on that date will be given effectively the same time to attend court, 9:30 a.m. for a 10 o'clock start. So in a typical courtroom, there may well be 10, 15, 20 cases listed in court that morning, with all of them effectively with a 10 a.m. time marking. That doesn't mean that the case is going to be heard at 10 o'clock in the morning. It means that the case may be heard at any point from 10 a.m. onwards. Which cases are heard and in what order, of course, depend upon a number of factors, which effectively they prioritise what are known as custody cases. So for people that have been refused bail and remanded in custody by the police and therefore are in the cells downstairs in the magistrate's court, those cases are usually prioritised. But in some courts, there's specific courtrooms that hear custody cases only. But in the first instance, custody cases are prioritised, and then beyond that, effectively, it's the manner in which the court's business proceeds according to which cases are ready to be heard. Sometimes some cases are relatively simple and straightforward, therefore they usually tend to be heard first. But there's all sorts of things whenever the solicitors are ready, if people are represented. Sometimes those cases will be given a certain amount of priority, but otherwise sometimes a solicitor might well be representing the client, but he's waiting for some papers to come through from the Crown Prosecution Service or for some further information, and therefore that case isn't ready to be heard right away. And in those instances, other cases may be heard prior to that one. So it's really as and when the day progresses as to which cases are ready, they're heard in that order, generally speaking.
So there's a real variety of different cases that can be heard on the day. And just generally speaking, how long does a case take on the day when you first hearing?
Well, again, it really depends upon precisely the offence that the person has been charged with, the nature of the allegations, what type of offence it is. And when I say type of offence, I'm referring to classification of offences. You might recall last week we spoke about the 3 different categories of criminal offences, being summary-only offences, which are offences that can be heard before the magistrate's court only, indictable-only offences, which are offences that can be heard before the Crown Court only, and then either-way offences, which may be heard before the magistrate's court or the Crown Court. Now, your question was, how long does a case take to be heard at the first hearing? Now, what it really depends upon is, firstly, which classification the offence falls within, whether it's indictable only, summary only, or either way, and furthermore, what plea the defendant is likely to be indicating or entering on that occasion. So firstly, if we deal with indictable only offences, which are offences that can be heard before the Crown Court only, typically when a defendant is charged with an indictable only offence, they do not enter or indicate a plea at the Magistrates' Court. The case is identified as being indictable only, and the case is simply sent, that means transferred, straight up to the Crown Court. So usually those type of cases sometimes only take 2 or 3 minutes to deal with.
Okay.
Occasionally it can be a little longer if there's another offence associated to the indictable only offence, or there's issues concerning the defendant's bail conditions which need to be ventilated and argued in court. But typically those sort of cases are relatively straightforward because they're simply being sent, meaning transferred, up to the Crown Court, so those hearings sometimes only take 2 or 3 minutes.
Okay.
On the other hand, of course, there's cases which can be more complicated, and cases are usually complicated by the fact that the defendant actually admits their offence and pleads guilty to the offence. The reason I say that complicates the issues is because there's much more to be dealt with at that hearing.
Okay.
Because when a defendant pleads guilty, the court sometimes, depending upon their powers of sentence, whether they're sufficient or not, will proceed to sentence either on that occasion, or sometimes they will adjourn the proceedings for the preparation of a pre-sentence report from the probation service, so that they can have a meaningful, what used to be called a social welfare report effectively, about the defendant, their background, their personal circumstances, so that the court knows something about the defendant that they're sentencing prior to proceeding to sentence. So those hearings can typically take much longer, because if the court does proceed to sentence at the first hearing, which the court is entitled to do so, then the court will need to hear much more about the facts that are being alleged by the prosecution against the defendant. They will want to hear a summary of the Crown's entire case, whether there were any witnesses, any aggravating factors, what are known factors that make the offence more serious, mitigating factors, which are things that make the offence less serious. They'll also want to hear about the defendant's background, precisely what he's admitting, he or she is admitting to, the mitigating circumstances around the defendant, sentencing guidelines. Sometimes the court has to consider case law. There's a whole realm of things that have to be considered. And if that obviously happens on the first occasion, which it can if the defendant pleads guilty, the court will, if they feel it's appropriate, proceed to sentence, particularly if it's a summary-only offence. And in those circumstances, the hearing could take significantly longer, sometimes even up to an hour.
Okay. Wow, that's really interesting. So you would have thought that if somebody pleads guilty or they admit they've been guilty, you would have thought that would have made the whole process a lot more simpler, but it can be really complex too.
Only on that first occasion.
Okay.
Of course, a case going to the Crown Court is much more complicated in the long run, because in due course, when that case is in the Crown Court, it's going to take up a lot more time in the Crown Court than a case pleading guilty at first instance in the Magistrates' Court. But on that first occasion in the Magistrates' Court, dealing with the first hearing only, a defendant pleading guilty when the court proceeds to sentence, invariably the hearing is going to last a lot longer than a case simply being transferred to the Crown Court.
All right, okay. And now that actually ties in quite well to our next question, which has been kindly sent to one of our friends, well, one of our viewers watching from home on Facebook. They sent the message, can you actually go to jail after your first court hearing? Is that a possibility?
It's certainly not impossible.
Okay.
Because, of course, the majority of criminal offences do carry custodial sentences. Granted, not all, but the majority of criminal offences do carry a custodial sentence. Typically, summary-only offences usually carry a custodial sentence of up to 6 months, which is the power of the magistrates to send somebody to prison for up to 6 months. But it really depends upon the precise offence that the defendant is charged with, the circumstances of that offence, the aggravating features. If it's an offence of an assault, for example, the level or the extent of the injury, the consequences of that injury, the way in which the offence was committed, whether a weapon was used or not. And in all the circumstances, of course, a defendant can, in theory, be sent to prison immediately following the first hearing in the Magistrates' Court. It will also, of course, depend upon the defendant's antecedent history, such as their background, whether they have any previous criminal convictions, cautions, reprimands or warnings whatsoever or not. Sometimes people do, sometimes people don't. But yes, to answer your question, a defendant can be sent to prison on the first hearing, which is why it's so important for anybody first appearing before the courts to ensure that they're fully prepared, because people must not assume appearing before the criminal courts is a simple, trivial matter. It's not. The court will expect on the first occasion for typically the defendant to either enter a plea or indicate a plea. If the defendant indicates a guilty plea or enters a guilty plea, the court may well proceed to sentence there and then, which is why it's important for any defendant appearing before the courts to always have the benefit of some level of independent legal advice and representation, if possible, so that they are making an informed decision prior to entering their plea, that they've fully been informed and advised, and they know the consequences of what they're doing.
Okay, just in case things don't go in their favour, to have some support available. That's fantastic. Also, we can summarise to say that everything is dealt on a case-by-case basis, which is fantastic. We've just been received another message online on Facebook, just leading on to this question as well, which is, at what point would a jury come in and under what circumstances? What's the question?
Right. A jury is only relevant to trials in the Crown Court. There's no jury in the Magistrates' Court, for example. So a jury would only be involved if a case is sent up to the Crown Court and there is a trial in the Crown Court, because trials in the Crown Court are heard before a jury comprising 12 random members of the public, 12 peers, who are selected randomly from the electoral roll, and the jury would hear a trial in the Crown Court. And it is the jury and the jury alone that decide the facts in the case. So if a defendant is charged with the commission of any criminal offence and pleads not guilty, it is for the jury to decide whether the person is guilty or not guilty. It's not a matter for the judge to decide.
All right, okay. And just another question that has been raised. What if the jury members have a 50-50 opinion and it's quite split and there's no burden of proof?
If it's 50-50, there's a hung jury, a mistrial is declared and the jury is discharged.
Okay.
And then if the prosecution wish to proceed, they have to have a retrial.
All right, okay. Well, so that's a very short question, but also very straight to the point answer as well, which is fantastic as always. So that leads to our next question. So we were talking about earlier about, being pleading guilty out of court cases. There's different types of ways you can plead guilty. What we're wondering is, since you're an expert in the field, what are the five different types of ways you can plead guilty?
5 different ways?
Yeah.
What?
For example, guilty, not guilty, and kind of elaborating on what that means.
Yeah, certainly. I mean, the decision as to what plea for any defendant to enter is an extremely important decision.
Yes.
It is not to be taken lightly. Sometimes people take the view, well, if I've hit him, for example, then I must be guilty, so I'll plead guilty. But that isn't necessarily the case.
Yeah.
Because if a defendant is charged with an offence of assault, he isn't necessarily guilty just because he has hit somebody or she has hit somebody. A person is only guilty to the criminal burden and to the criminal standard if they have committed the criminal offence of assault. Now, if, for example, a defendant has hit somebody because they feared for their own safety, or they were doing it to protect or defend themselves, or to launch a preemptive strike, which is effectively to hit somebody before they hit you, then that is consistent with self-defence. Self-defence entitles a defendant to protect and defend themselves in certain prescribed circumstances. Of course, self-defence has to be measured, it has to be reasonable, proportionate, it has to be necessary. It doesn't allow for a tit-for-tat reaction. So it doesn't allow, well, I hit him because he hit me. But it allows one to protect and defend oneself. So it is so important to know the precise facts, the allegations, the evidence supporting those allegations, and the defendant's instructions prior to any defendant being properly advised as to whether the most appropriate plea for them to enter is one of guilty or not guilty. The reason that's extremely important is because with any defendant entering a plea, that is an important decision that shall invariably impact upon them in the future. For example, if a defendant pleads guilty, immediately they end up with a criminal conviction. If they had no prior criminal convictions, they lose their good character. That therefore affects their reputation. Secondly, a defendant's career, their employment, their income, their livelihood might be affected by virtue of that conviction. Because as we know, certain employment isn't possible to have a criminal record. But otherwise, it could mean that either if somebody hasn't got a career, they might find it difficult to embark and enter their chosen field or career. But sometimes they may lose their employment. For example, a school teacher convicted of an offence of assault, typically a school teacher will end up eventually losing their employment by virtue of having a conviction for an offence of violence on their record. So that's important. Beyond that, not only does it of course affect the reputation, but the livelihood, but also liberty. A defendant, as we've discussed earlier, is at risk of losing their liberty by the imposition of an immediate custodial sentence. So all of those things and the consequences that flow from a guilty plea can be extremely dire. And in those circumstances, the defendant must receive proper and meaningful advice as to their plea. Conversely, entering a not guilty plea, of course, if somebody denies an offence, typically the most appropriate plea for them to enter is a not guilty plea. However, it's very important for any defendant to have the benefit of proper meaningful advice prior to entering that not guilty plea, because it may well be that they're actually guilty, and by pleading not guilty and unnecessarily and needlessly proceeding the case to trial, that further evidence is unnecessarily caused, and eventually when they are convicted, that may well end up aggravating the sentence, which means they may end up getting longer, because within the criminal justice system we have a principle known as credit for a timely guilty plea. What that basically means is a defendant that pleads guilty to an offence at the first and earliest possible opportunity receives credit, that is a reduction in sentence, following the imposition of a prompt and timely guilty plea at the earliest possible opportunity, as opposed to a defendant that protracts the proceedings unnecessarily, enters a not guilty plea, takes the case all the way to trial, needlessly creates witnesses and causes witnesses to have to attend to court to give evidence, questions and cross-examines those witnesses, wastes court time, causes further distress to the complainant, victim, witnesses, etc., then that defendant invariably ends up receiving a longer sentence or a much harsher sentence than that which they would have achieved had they pleaded guilty at the earliest possible opportunity.
Okay. So essentially, without having the correct legal advice, it makes life a lot more difficult in the court hearings. Exactly.
And not only is legal advice important from the perspective of somebody with the technical and requisite legal knowledge and skill being able to advise you, but of course, one thing that any advice gives us is objectivity. Because typically, anybody accused of anything, not just a criminal offence, always looks at things from their own viewpoint. That is because they're looking at it from their own viewpoint alone and not looking at things standing back from a bird's eye view objectively back upon the situation. So one of the other advantages, aside, like I say, from the legal expertise and knowledge that can be benefited from, is the benefit of objectivity, somebody else looking upon the situation and saying, well, actually, are you sure that you're acting in self-defence? Because, for example, these were the facts and circumstances, this is how you reacted. Do you think that you perhaps overreacted, so it might well have started off as self-defence, but it went beyond lawful self-defence? And those are the sort of things that sometimes can cause a defendant to reflect upon his or her actions and then take a different view to that which they would otherwise have taken in the absence of any legal advice.
Fantastic. So legal advice can also help you gain a bigger picture of the whole scenario.
Certainly.
That's fantastic. Wow. So if you just rewind a few minutes before, we've received a message on Facebook from one of our lovely viewers watching at home, and they were stating that when we were talking about self-defense, they have a case scenario that they've recently gone through in life. So they were talking about how they went to the train station during a night time, and they got robbed and they got mugged by an anonymous person. They don't want to mention the name. And that person who got mugged was a Amritari. He was having a qurban on him. And for self-defense, he really felt like getting his qurban up because he was mugged to a point where he could really injure himself. But because he was unaware of the situation, he didn't do it. So eventually he just took the beating and he's given a few beatings back. But we won't, give out the information too much. But that's what essentially what happened. And what he was wondering was it right for him to take out the Qurban and use it as self-defense?
It really depends upon the circumstances of the aggressor, the assailant, as to what was the level of force that assailant was using, whether that assailant was using any kind of equipment or weapon to threaten or brandish the Singh with, and to what extent was there that level of imminent danger. So we would really need to know much more about the precise facts and circumstances before being able to advise. But per se, somebody could, in theory, defend themselves with a Qurban, but it's a question of what do you do with the Qurban.
Okay.
So it's not the fact that you use it, because sometimes it may well be used, because of course it is a defensive artifact to defend oneself. And there's nothing wrong, in theory, in using a Qurban to defend oneself. But it's a question of what do you do with it, how far do you go, to what extent do you defend yourself.
Okay.
So you've got to look at the circumstances. If, for example, the assailant is simply coming towards him with a clenched fist, and the victim produces the Qurban and decides to actually wound the assailant with it, that arguably is not self-defense.
Okay.
But if, however, the Qurban is produced to ward off the assailant,
okay,
so that he stands back, takes attention, and then leaves, that, of course, in those circumstances could be argued as lawful use of that artifact.
Okay, and you won't get guilty, you won't plead guilty
well,
to it?
I can't say whether you go guilty or not, because it depends upon which offence he's charged with. I mean, typically, it's been the practice of police to usually, in those circumstances, to charge a defendant with an offence of possession of an offensive weapon.
Okay.
But of course, there's a defence to that charge, and the defence is one of lawful excuse. Now, if somebody has a lawful or reasonable excuse in being in possession of that article in those circumstances, then of course that can entitle a defendant to a complete defence.
Okay, wow, that's really interesting. So we have 2 minutes left of the show, and we're going to make really use of this time by completing the whole question that was raised by one of our lovely Facebook members online. So if you have any questions, do feel free to always send us some questions online, but we're going to finish this final question off. So if we were to, let's say the person who was trying to attack the person, the receiver, let's say if he did have a weapon, let's say if he had a knife, would it be right for you to take out the Qurban as well?
Like I said, it really depends on the facts and the circumstances, because it may well be that a knife was more readily available, or the Qurban was more readily available to him. But you've really got to look at the actions and the conduct of the assailant. If the assailant had a weapon, then it's quite likely that using a Qurban to defend himself may well be justified.
Okay.
But if the assailant was unarmed, it's less likely to be able to justify the use of a Qurban in those circumstances. But again, every single case is considered by the courts on a case-by-case basis, and therefore the precise facts of the incident have to be analysed.
Okay, wow. So on the topic of talking about attackers, just quickly another question on Facebook. We're going to try to get through all these before we finish. So the last question is, so let's say you have a trespasser who comes on your property. Is it right for you to attack the trespasser if he doesn't once you give the verbal warning and he doesn't move off your property?
A person that is the owner or freeholder or possessor of property is entitled to have free, unadulterated use of that property. So you're entitled not to have people trespassing into your property.
Okay.
And if somebody does trespass, then you're entitled to use reasonable force to remove the person from your property.
Okay.
Question is, what is reasonable force? Now, at the lowest end, it perhaps may comprise of pushing the person away, removing them, but it's a question of how far does the person go. If you start to use weapons to try to forcibly remove that individual from your property, particularly in circumstances where the person isn't presenting any immediate threat or danger to you, then it's unlikely to be justified in law as a reasonable use of force.
Okay, wow. So, Satsang ji, these were all the questions that were sent in today. We have quite a lot more as well, but unfortunately we can't go through all of them. But if you stick around for next week, Satsang ji, every Wednesday, 7 o'clock to 7:30, the legal show, your favourite show, we'll both be here presenting the show for you guys. We hope that you guys have learned something very informative today. And Baji, how do you feel? Do you think the show went quite well?
I hope so.
Yeah.
I hope so. I mean, we've covered a lot of ground, a lot of content and material in terms of the process from the first magistrates court hearing upwards, precisely what can happen at that hearing. And overall, the biggest message really is the importance in any defendant being charged or prosecuted, summoned to appear before the court, in receiving the benefit of independent legal advice prior to that first hearing.
Definitely, definitely. So Satsang ji, before we finish off, we want to congratulate you all on the Dantan Shri Guru Granth Sahib Ji Maharaj Guru Gaddi Divas, which was yesterday. So many congratulations to the whole Sikh community and the wider community. But on that note, we want to finish off this episode. Stay tuned for next Wednesday. Vaheguru Ji Ka Khalsa, Vaheguru Ji Ki Fateh.